All right. This is July 12th, and this is an interview with Professor Phil Higdon, who is an adjunct professor and also is a lawyer at Brown and Bain. And we are here to talk. Okay. Well, the first question is, how did you decide to go to law school, and was it what you expected when you got there?
Well, I tell this story about myself. When I was about 10 years old, I had a slightly older friend who was an usher in a movie theater. And I had a deal with him that I would go on Friday night, he'd let me see the double feature for free if I'd help him clean up afterward. And one night I remember there was a double feature featuring Witness for the Prosecution with Tyrone Power and Marlena Dietrich, and some war movie. The next day this fellow's father asked me which movie I liked better, and I said Witness for the Prosecution, and he said that figures. I think I was destined for law school probably sometime before then, and it was never really an issue for me. It was just always what I planned to do. When I was in high school, I knew I was going to law school. When I was in college, I knew I was going to law school, and it happened. So there was never any doubt about that.
Did you come from a family that were lawyers?
No, no, but I started political activity at about the age of 8 or 10, and was just always interested in that part of it. I would watch shows like Perry Mason growing up when my pals were watching Wyatt Earp, and so it just was a natural thing for me. And I have to say that I had no surprises, particularly at law school. I mean, it was pretty much exactly as I expected it. I fell into, very fortunately, an outstanding study group that I worked with, particularly my first year, but really throughout law school. And it was a great environment for me, and I thrived on it and loved it, and it was exactly what I was looking for.
And did you always want to go into civil litigation and media and contracts and things that you do now, or was that a...
Actually, all that was pretty early on, too. I was a debater in high school, I was a debater in college, so litigation came naturally. And I actually worked in radio and television in high school and college as well, and majored in radio, television, film in college, got a master's degree in radio, television. So again, that was all kind of pretty basic stuff. And I've always been interested in the media, what they do, how they conduct their business, First Amendment issues. So that was all very natural for me.
And what made you decide to teach as an adjunct?
Teaching is something that I've always enjoyed doing. Again, I've had some teaching jobs in other fields off and on, again since high school, but my firm had a sabbatical program where you could take what turns out to be the equivalent of a semester off the practice and go do something else. And I took my first sabbatical 20 years ago and taught full-time at a law school back in New England, just because it was something I wanted to try. And I think that experience told me, at least at that time, that I didn't want to do it full-time, but I wanted to keep my hand in it, and I wanted to do it from time to time, and that's why being on the adjunct faculty is so perfect, because it does give me a chance to do that when I'm able, and I do enjoy it.
Why didn't you want to teach full-time?
I think I missed the combat of litigation. I enjoyed the sort of the day-to-day grappling that you have. Teaching full-time was a bit too academic for me to do as a full-time endeavor. So I wanted to go back to do litigation, which was really my first love, but I wanted to keep my hand in teaching also.
And what do you see as your role as an adjunct? There's a lot of discussion now about sort of what should the law faculty look like, and sort of what do you see your role as an adjunct?
Well, I think adjunct faculty plays a very different role than full-time faculty. I've often been told law school is not a trade school. This is an experience to teach people how to think like lawyers, how to study the law and all of that, which I think is true. But I think there also need to be some practical aspects to it as well. I think students want that. I think a lot of people get out of law school feeling frustrated because they know a lot about contracts and constitutional law, but they don't know the first thing about what to do with that knowledge as a practical matter. And I think the adjunct faculty can help with that by putting some of this into context. So that when I teach my course, you know, we go through the cases and we talk about the theories and all of that, but I also give them a lot of, I think, very practical experience, guidance, how to write, how to think, how to argue, how to approach a case, and that type of thing. Not to substitute for what the full-time faculty is giving them, but as an addition to that.
Talk a little bit, since I've taken your class, it's kind of hard for me to ask these questions, but in terms of how you structure your class, there's a lot of, there's presentations and each person takes a different side of it. What do you think the value of that is, as opposed to having everyone read the book, and sort of, do you see sort of this, how did you come to sort of that way of choosing to do the class that way?
First value is there's a lot less work for me, which is important. I came across this because I think it's a way to get everybody engaged. I think particularly for a law school class to work, everybody has to feel part of it, everybody has to participate, everybody has to have a stake, I think, in how successful each class is. This way, as you know, we have two students who are leading the discussion, one taking opposite side of the other for most of the class, but members of the class are encouraged to pipe in any time with their questions, thoughts, comments, whatever it is. So there's a lot of give and take. And I think that way everybody kind of feels like they have a stake in it and feels like they've been a part of every class, and I think that's important.
There's I'm going to jump around a bunch today.
Okay.
There are controversies, or not controversies, but there's lots of discussion about sort of the makeup of faculty, and there's this sort of growing trend of JD PhDs, which I'm, biased, of course, but do you have a feeling about sort of lost professors who've never practiced, never been in the world? Do you have a thought about, is there a place for just academic professors? It's the opposite side of the adjuncts that come in, and I thought maybe sort of your view on that, since we're trying to get a sense of community.
Law school is a unique experience, and for most lawyers it's really the last opportunity they're going to have to sit down for 3 years and just think about not only what the law is, but what it ought to be and how it got to where it is. And I try to do some of that in my class too. And so a lot of the study of law in law school is academic, purely academic, and it ought to be. And there are people who are professional teachers who approach that aspect of the subject matter far better than those of us who have labored in the vineyards for 20 years or more, because we have a very different view of things, somewhat jaded perhaps by our experience. So I think there's a place in law school for both types. I think it's important for the student to understand what the background of this particular professor is. I will understand that when I get this information from this professor, I'm getting this information from a person who has not practiced law, but who has done a lot of studying and writing and thinking and cogitating. And therefore, I will take what I get from her this way. This other person has been practicing for 20 years. They're coming at it a little more differently. Perhaps has a few more notches in their gun belt and a few more wounds that have healed over the years. And I'll understand when I get the information from this professor. So as long as the student, I think, is acquainted with where this information is coming from, I think all of it's valuable.
And when the young lawyers come, or the summer associates come to your law firm, do you expect that? I think sometimes students worry that if they only have this very academic person teaching them corporations, that they're unprepared and that it's going to somehow put them behind the curve when they get to their post. Do you expect anything that they know very much when they get to you, or I don't know.
No,
what I'm saying.
Yeah, I understand. I think the whole purpose of a summer clerkship or some kind of clerkship during the academic year, the whole purpose is to provide that very experience, which we don't expect people to have had before. Frankly, I think sometimes we tend to forget what people do and do not learn in law school, and so we tend to assume they know more than they do, or take for granted things that we know that they don't know. Not so much on a substantive level as, say, on a procedural level. If I ask somebody to go draft a summary judgment motion, I may assume erroneously at the beginning that they know what a summary judgment motion is. And so my job, I think, is to sit down with them and say, here's what a summary judgment motion is, here's what you got established to win one, and let me give you some pointers on how to get there. We hope that they'll know a lot more at the end of the summer than at the beginning, but we don't expect them to know that much in terms of practical knowledge at the beginning.
So, in great part, you're a teacher at the law firm as well.
Yes. Yes, and I think that's part of our responsibility.
Do most of your colleagues agree with that, or do you think it's become more of a business and we shouldn't spend this time, that the law schools should be training them and we shouldn't have to do the training here?
Well, it's all part of a deal that we make when we hire somebody for a summer. First and foremost, a summer clerkship position is a recruiting tool. And we hope that people who come through our summer program will work out, will like us, will like them. At the end of the summer, at the end of their law school career, at the end of a judicial clerkship, we'll make them an offer to come join us as an associate. They'll accept, and that's great, because obviously if you've had an experience with someone over the course of the summer, you know a lot more about them than you're going to learn through a 20-minute interview. So that's part of the deal. But another part of the deal, I think, is this teaching. And I think most lawyers, especially litigators, are frustrated teachers anyway. They like to be in that role. They like to be in a role of teaching people something, whether it's sitting in an office talking to a law student or standing in front of a jury. And that's really what they're doing. So they like that role. I think the hardest part for lawyers in terms of the teaching experience is not teaching on the front end, but critiquing on the back end. When they turn in, the law student turns in an assignment. Professors are used to grading, and professors are used to telling people how they did. Lawyers don't like that, by and large. That's often the hard part, just to get them to do it. And so I think that is a frustration that many, many summer clerks share in almost every law firm I know about, and it's one that we have to constantly worry about.
What kind of questions do you think a potential summer clerk should be asking in that interview? You only get a couple shots at sort of figuring out where you're going to go. And I don't think people really have any idea what they should be asking or looking for. Do you have any advice on that, or is that just a hard thing to stumble through?
Well, I think something everyone should find out is, tell me how your summer program is organized, how it works on a day-to-day basis, how do assignments get to people, what sort of input am I going to have in the kind of assignments I get, what do you do to make sure that I'm going to get a full summer experience, because it's not just a matter of collecting assignments, going to the library and writing memos if it's done properly. People should also be exposed to trials, to hearings, to oral arguments, to depositions, to client meetings, to negotiating sessions, whatever's going on in the office that summer. And again, I think it's part of the firm's teaching responsibility to offer that exposure. So I'd want to know, how do you go about doing that? How do you make sure that I'm going to have these opportunities? Or am I going to be stuck in the library all summer? Because if that's the case, I want to know that too. Because you're not just there, in my opinion, to learn about substantive areas of the law. You'll get that in law school, and you'll get that in practice when the time comes. I think you're really there to find out about this law firm, how it works, how it functions, and to find out how these people do their jobs. Mm-hmm. And that's part of it, and you need to find out how successful is the firm in doing that for you.
Okay, I'm going to ask you a couple negative questions on this, or sort of when things go wrong.
Let's see if I can spin
it. What happens if you get there as a summer clerk and you realize you don't really like it, and it's only the second week? Do you just keep going, or do you talk to someone, or does that happen?
Well, most law firms now offer some kind of mentor program, so that someone is assigned to you to be your confessor over the course of the summer. And they say to you, if you have any particular problems, feel free to go to this person and talk to them about it. I would take them at their word, and I would go talk to that person and hope that this person turns out to be someone who's worthwhile in that position. Some law firms will give you senior partners in that role. Most law firms will give you relatively junior associates who have been where you are not so long ago. Now, they may not have the clout to make everything happen that you want to have happen, but at least they're sympathetic, and they ought to be, and they ought to remember what it was like when they were in your position, and they ought to try to help out where they can. So if such a person is assigned to you, that's the first place I'd go, or usually there is someone who is in charge of the summer program, or in charge of recruiting, or in charge of something that would make them the natural person to go to. But I would speak up early. Chances are it's probably a personality issue with one or two people, particularly if you've only been there a short period of time, rather than some kind of firm-wide problem. And so maybe the answer is as simple as getting you assigned to somebody else. But after that, I would just speak long and often about the situation without being obnoxious about it, and see if you can't work together on getting it solved.
All right, here's another question for you. We talk to lots of people, and there's always a sense of like the big firms, the corporate firms, the high-paying firms, and everybody else, and there's sort of that sort of dichotomy of like, are you going to be one of those that get paid a lot and have long billable hours and not? And Brown and Bain is, for Tucson, that space. Am I correct?
Except for the high-paying part.
Well, and so my question is sort of, how do you respond to sort of being the sort of, you're in the space of sort of the golden egg and also the thing that everybody bashes. I mean, there's a sense of this weird space that everything's measured against sort of what you guys do. You being in that space of, whatever. And I don't know, it's not really a question, but if you have a response to that.
Well, first of all, there is no correlation between either number of hours worked and pay and size of firm. I know plenty of lawyers who work in very small law firms who work very long hours and make a lot of money because that's the environment they choose to work in. So by going into a law firm, a large firm, does not mean that you're going to have a different lifestyle necessarily than being in a small firm. By the same token, joining a small firm does not mean you're not going to work long hours, you're not going to make a lot of money. The practice of law, whatever size firm you get involved in, is what you make it. So I would say that. I mean, I understand the stereotypes you're talking about, but I know several colleagues of mine who have left my law firm to go out on their own because they wanted to spend more time with their family and are working harder now than they ever have before. And frankly, are making more money than they would have had they stayed with us. So it's all a matter of perspective. There is a different environment between working in a big firm and a small firm, although for different reasons. And I think it's just a matter of personal preference. There's no right way to do it, there's no wrong way to do it. It's a matter of where you're most comfortable and what you like to do. I happen to think I have the best of both worlds because I am in a relatively large firm by Arizona standards, but most of those lawyers are in Phoenix. The office I work in is pretty small. We have 10 lawyers. For me, that's ideal because I have the advantage of working with 9 people that I happen to be very fond of, and we get along very well together. We know what each other is doing and back each other up. But we got that big bunch of lawyers up in Phoenix available to us. If we get into areas of expertise that we don't have, we need a tax lawyer, we need a securities lawyer, we need a labor lawyer, we can go to Phoenix and grab one of those. If we get involved in a large case that's too big for an office our size to handle, we got resources up in Phoenix we can draw on. By the same token, there are cases that come to the Phoenix office that actually are located down here, so we get fed business. And we, of course, send business the other way. So that, to me, is an ideal situation. They've got all the bureaucrats. They've got the accounting department, the human resources department, the information services department. All that's up in Phoenix. We don't worry about that. We just stay down here and practice law and try to pay the bills. So that's a very good relationship for me. There are people who are in our office in Phoenix who would never come down here because they love to be in the big office. They like the big environment. They like the big national litigation that they get involved in up there. And of course, there are people in Tucson who practice in smaller firms who wouldn't want a firm our size. And they're all doing good work, and they're all being productive, and they're all enjoying themselves and feeling satisfied, or not. But it's not a function of the size of firm they're in. But that really is a matter of, how am I comfortable? Where do I like to be? What kind of resources do I want available to me? How independent do I want to be? To what extent do I want to answer to other partners, etc.? And that's really a lifestyle choice.
Do you think that answering to partners and things like that is there's less of that in the Tucson Tucson side than in Phoenix? Is it a more casual atmosphere, or is it the same?
I think the Phoenix office would agree that our office has a more casual atmosphere than the Phoenix office. Again, I don't think that's, one is right and the other's wrong. It's a difference. We don't feel down here, by and large, that we are, well, I guess in a sense, we all feel responsible to each other, but in a positive way. As I said, we back each other up, and we provide support back and forth. And it's a very collegial atmosphere. The larger the office gets, obviously, the less everybody is kind of paying attention to what everybody else is doing. Our Phoenix office is spread over 3 floors. We have transactional lawyers who almost never bump into litigation lawyers, etc. So again, it's a very different relationship.
What about billable hours? That's always the big question. Are billable hours? Tell me about billable hours in your world.
Billable hours is the bugaboo in every lawyer's world. And again, I defy any lawyer, I don't care what size office they're working in, who will say, I don't worry about billable hours, if in fact they're practicing law for a living. That's just, unfortunately or fortunately, the name of the game. In terms of pressure for billable hours, our firm has certain, not minimum requirements, but standards. Numbers that we look at. But by and large, it's really a function at the end of the year of, how productive were we all, how much money did we make, and how are we going to divvy it up. And associates do have a certain, standard, and if they fall below that standard, somebody's going to come talk to them, to be sure. I know that in the very large firms around the country that have gone to these astronomical starting salaries, the billable hours are minimal expectations, are just off the chart as far as I'm concerned. And frankly, that's not an environment I would ever care to live in or practice in, but it attracts hundreds of new lawyers every year, some of whom thrive on it, some of whom hate it and leave it as soon as they can. But again, it's a choice you make. Do I want to make these big bucks? And if so, am I going to devote this kind of time to it?
All right, let me see if I can do this question. We've talked to a lot of people about lifestyle questions and choices and working long hours and short hours, and a lot of times we get sort of people talking about how when they first got out, they worked a lot of hours, but then they cut back when they have families, and then other people who, there's just all the whole variety. But the question is, what if you are young and you decide that you don't want to do the huge hours from the very beginning? Is there a place at a firm like yours, or do they need to find somewhere else?
Well, I think during the interview process, you ask those questions, and you do 2 things. You listen to the answers you get, and you look at the faces while the answers are being given, because you know what they're going to say, by and large. But you can tell by the facial expression if this is a question they welcome or not, because a number of firms do not want to hear the question. They consider, just by the very question, you are now a suspect candidate, just for asking. And you can kind of tell that. But I think you need to know going in. I think you need to find out exactly what the expectations are, and you need to tell them what your desires are. And if those 2 mesh, terrific. Go for it. But you're going to know, I think, through the interview process if there's a problem on one side or the other.
Do you think billable hours are, that your billable hours is more important than the quality of your work, or do you think the quality of your work is also being, because it seems that billable hours, there's just such an emphasis on billable hours, that the question is anyone looking to see what work's being done for those billable hours, or is
Okay.
that something too hard to evaluate?
Well, it's hard to generalize. I mean,
Yeah.
again, I think the honest answer to that question is going to vary from place to place. I will say, over my 20-plus year career, billable hours as a concept has grown more and more important. And as I say, that's a function of economics. Two things going on here. One is very, very high pressure in terms of starting salaries, which of course bump up everybody else's salaries. Somebody's got to pay for that. You know, it's no different than the baseball free agents whose contracts are driving up ticket prices. That's just the way it goes. That's the economics of it. So it's great, you know, that some folks are getting straight out of law school and falling into $200,000 a year salaries, but someone has to pay for that, and those are the folks making the salaries. Even for the firms who haven't quite reached that level for starting salaries yet, there's pressure too. That's part of it. The other is that I think clients over the years have become much more sophisticated. They're not just paying bills as they come in without looking them over and without checking them and satisfying themselves. Yep, that's a fair bill. And so law firms need to pay attention to what they're billing for and what they're not. And frankly, we write off a lot of time, particularly for new associates who are learning to do things for the first time. I can't bill a client for 6 hours, you know, that an associate put into writing a relatively simple motion that would have taken me half an hour. You know, but they need the experience, and that's great, but the client shouldn't have to pay for it. So all these things kind of go into it, and I think people tend to forget that billable hours don't necessarily translate into billed hours, and there may be a lot of, I don't want to say wasted time, but unprofitable time that the youngest associates in particular put in.
So, I mean, I guess when you put it that way, it seems like you could sort of see, like, the long hours as that, you know, you'll get more efficient and your hours might be able to be cut back because it won't take you the 6 hours to do the brief.
Right.
And that, in part, the long hours are due to the learning curve.
Absolutely. And you asked about quality, and I didn't want to skirt that one, because I can't imagine a law firm where billable hours have become so important that quality is no longer important. And I can certainly say in my firm that's never been the case, and it never will be. We do a lot to pay attention to the quality of the work that we're all doing, particularly our younger associates, but there's no partner in the firm who has cases that somebody else isn't assigned to also. And we recheck our work, we hand drafts back and forth with each other, and we talk to each other about approaches to cases. We have a full formal training program that our associates go through, transactional or litigation as the case may be. People are looking at their work. And as I say, when the timesheets come at the end of the month and we decide what's going to get billed to the client, we take that into account also.
Because we've done some good stuff on this summer associate stuff, and we haven't done too much of that yet in our interviews. So a student's watching this and they want to know how to be a successful a summer associate. Do you have any particular advice in terms of when you get to that firm, just in general? And also, there's a lot of talk about sort of getting to know people in the sort of social part of law. And is there how much of the social part is the summer associate supposed to be sort of focusing on as opposed to the work part? Does that make sense? The sort of personality, sort of schmoozing part.
How to be a successful summer associate. First rule is do good work. Nothing serves a summer associate better than at the end of the summer having everybody sit around the table and say, her work was fantastic. Personality is important, schmoozing is important, expressing an interest in what you're doing is important, being engaged is important. Knowing which fork to use is important, but nothing substitutes for good quality work. And so I would say, pay extra attention to the quality of the work product that you're turning in. Make sure it's the very best that you can do. I know some people turn in work product and say to themselves, well, the partner in charge is just going to rewrite this thing anyway, so it really doesn't matter how good it is. Those people are making a serious mistake. Assume that what you turn in is what's going to get filed or what's going to get sent to the client or sent to the other side. Nobody else is going to look at it. Make it the very best you can, because nothing else counts as much as that.
Should you worry about how much time it's taking you to get the very best?
No. Now, the signing lawyer may tell you, I got to have this by Wednesday, and that's just all there is to it. And so you put in as much time as you need between now and Wednesday to get it done. You turn in the best product you can on Wednesday. But the signing lawyer may also tell you, there's no particular hurry on this, just give it the time that you need. And in a case like that, again, don't worry about how much time you're spending on it. Write it all down. Let somebody else worry about how much of that is going to get billed. Don't say, gee, I spent more time on this than I should have. I can't charge the client for that. I'll put down less time. We need to know, we need to understand how much time it took you to do a project, so that we can continue to improve our ability to estimate how long the next project will take. But you really need to know, I think, how much time have I got? When do you need this? How important is it? What other assignments have I got? Is there a problem finishing this for lawyer A if I got lawyer B breathing down my neck? I mean, you need to be sensitive about those issues. But again, the best answer is communication, and just find out what's expected of you.
What happens if they give you an assignment and you have no idea what they just said to you? Do you just,
ask.
Just ask.
Ask.
You won't be panel. I mean, there's a sense, I think summer, again, from what I've heard and a little bit of experience I've had, there is a sense of being afraid. I mean, you're in a new environment and you want to please, so.
Look, as I said, it is very possible that I will give you an assignment to write a summary judgment motion, assuming you know what a summary judgment motion is. You don't. I would rather you ask me right then and there, what's a summary judgment motion, than you go out, try to figure it out on your own, and bring me something back that is totally useless to me. Different lawyers may feel differently about it. I feel much more comfortable if somebody is, and you're right, confidence is part of this, confident enough to say to me, I have no idea what you just said. But frankly, that's part of being a lawyer. A lot of what gets thrown at you throughout your career is stuff you never heard of before. And you just got to get used to figuring out how to figure it out. And the first thing is, ask the people who know.
Okay, I want to ask a little more about the summers because we're doing such this good stuff, and I know that students are really interested in all this stuff. Okay, you go to lunch a lot, and you go to dinner a lot. What are you supposed to be talking about? I mean, they ask you questions. I mean, is there any strategy to that? Just be pleasant. Particularly if you're shy and you don't feel comfortable with the people that you're with. Do you have any advice for them on that?
Okay, we're not interviewing anymore, right?
No, you've been taken to lunch, and it's a lunch thing or a dinner thing.
I think there are probably two ways to go on that. You either talk about work, or you don't talk about work. Those are your two choices. Personally, I hate to talk about work during what is supposed to be a social lunch, and some summer associates in particular feel they're almost obligated to talk about work. So let's spend the whole lunch talking about this case. And maybe there's a reason to do that. Maybe there's something that you're under the gun and you really need to get something out and you got to talk about it. So do that. Otherwise, I would say the sky's the limit. I mean, whatever the two of you or three of you or however many there are can find that you have in common to talk about. I don't think there's anything particularly off limits. I won't begin a conversation with a law student or anybody else I don't know very well about religion or about certain other potentially sensitive areas. But politics, movies, books, rock climbing, whatever it is that you have in common, I think is perfectly appropriate. And it doesn't hurt to let the lawyer kind of lead the conversation.
Is the summer? I'm going to just keep going on this. Is the summer program an audition? I mean, are they just constantly on sort of interview mode? I mean, has the interview just not stopped in some way?
I'll give you a firm yes and no on that one. Yes, the summer clerkship is an audition. I don't know that it's fair to say, every waking minute of every hour of every day is an extension of the interview process. But I mean, there's no doubt about it. I mean, as I said, first and foremost, this is a recruiting tool. And at the end of the summer, you're going to know far more about these people than you're ever going to know about someone you just plucked out of the placement office. That can work to your advantage or to your disadvantage. Depends on how things go. And I know people who interview very well, make an excellent first impression, get themselves summer clerkships, and for whatever reason just can't sustain enthusiasm for themselves over the course of 2 or 3 months. And so they're probably disadvantaged by going through the process. But I guess it's better to know that sooner rather than later. But as I said, I think really the key element is the quality of the work product. And yes, that is being judged with every assignment. And it's not that we expect excellence in the first assignment, but we do expect improvement over the course of the summer. We hope that you learn enough and kind of build on that so that by the end of the summer you're doing much better quality work than you were at the beginning. That's really what we're looking for. But in terms of how you act, there are horror stories, I'm sure, in every law firm about summer associates we have known who committed unspeakable acts during the course of the summer. That's just legend and lore everywhere you go. So avoid trying to be one of those people and do good work, and you'll probably be fine.
Okay, last question. What about table manners? I know that's a ridiculous thing, but you eat out with people all the time. I mean, should you be aware of sort of, the way I know that sounds like a really ridiculous question and maybe obvious, like just have proper table manners, but should people be
I would say if you're concerned about that, you might want to pick up a Miss Manners book while you're at it. But by and large, I don't think the standards are terribly high.
It seems like you're coming into a culture, a particular culture, and there are certain things that you should know. And is that true as a summer associate, that you should be able to sort of move within this new world, or is that not quite the case?
On the subject of table manners, I guess we all sort of have minimal standards. But more generally, I think it's very, very critical that you not try to be anyone other than yourself. I know that's trite, but it happens to be true, particularly over the course of a summer. You might be able to pull it off in an interview, but you're not going to over the summer. And if you spend the entire summer sort of bending yourself out of shape to meet some ideal you think this law firm has, both of you are going to be very disappointed in the long term.
This is good. Okay, we'll move on to a new topic. But do you have any other thoughts before we go off to summer associates?
No.
This has been great. I think it's really, really good. All right.
How are we doing over there? Are we satisfied?
Great.
Oh,
Awesome.
Okay. Dealing with difficult. Okay, we've spent a lot of time on that, but it's really. I know that people are going to be really happy that we did.
Okay.
So I don't know which ones you want to do next. So we have dealing with difficult clients, doing litigation pros and cons, and what a non-lawyer courtroom lawyer does. Is there one that you'd like to start with?
Nah.
We'll do dealing with difficult clients. How do you deal with difficult clients, and do you have examples of different scenarios or sort of ways you deal? And what is a difficult client, in your opinion?
I just picked this topic because I wanted to tell one of my favorite stories.
Oh,
good. Tom Chandler, who's one of the great legendary trial lawyers here in Tucson, tells the story about a fellow who gets sued after he runs his pickup truck into the rear end of another vehicle. And during the trial of the lawsuit, he is constantly criticizing his lawyer about how he's handling the case. Why did you ask that question? Why didn't you object to that question? How did you let him get away with this? You got to stand up to the judge. Finally, the lawyer's just had it. And he turns to his client. He says, Fred, we're not here because I don't know how to try a case. We're here because you don't know how to drive a truck. And I think that story illustrates the proper role between a lawyer and a client. You have to, and I don't mean this is necessarily something that you do on paper or that you beat up on anybody, but you've got to establish with the client, look, these are your areas of responsibility and expertise. These are my areas of responsibility and expertise. And yes, the client ultimately makes the decisions because the client's paying the bills. But if we're in a situation where the client is not following the lawyer's advice, the client probably ought to go get a lawyer with whom they have enough confidence that they are going to follow their advice. It's just not a good relationship. So it needs to be understood. You're hiring me at an outrageous hourly rate because I know things you don't. So let's take that into account. And I think it's important that both lawyer and client understand that part of the relationship. That's fairly key to how this goes. As long as that's set out, I think, early on, then things go well. The other key thing about a lawyer-client relationship, I think, particularly when you're starting out together, is something that my mentor, Jack Brown, emphasized a great deal when he was teaching us when we were young. And that is the importance of establishing reasonable expectations. If the client comes to you and says, I want $1 million out of this case, and you decide that if everything goes perfectly, the very most this client could ever hope to achieve is $100,000, then even if you do everything humanly possible and succeed in every way, at the end of the case, you're going to have a disappointed client. So it's very important that you and the client agree. I understand what you want. This is what you can likely expect. This is the best you can expect. This is what we're going to shoot for. And again, if the two of you can agree on those expectations, great. If you can't, that's the time to figure it out, and that's the time to go for the client to go find somebody else that they're happier with. I think those are two important keys.
So, when you don't agree, how do you deal with it?
Well, if it's fundamental, as I say, if it's just a case where nothing I can do is going to make the client happy, I don't want that kind of relationship. That's just going to make everybody miserable. Now, that's not to say I never disagree with my client. Of course I do. And sometimes I do things because my client tells me to, even though it's against my advice or even though it's not what I think is the right thing to do next. Not right in a moral sense, but in a strategic sense. I do that because they are paying the bills. And as long as it's not a fundamental difference or philosophical difference, something I can't live with, we can proceed. But again, if it does get to be fundamental, I think you just sever the relationship or everybody's going to be miserable.
What if you find out your client is lying to you?
Well, if my client is lying to me, I find that a fundamental difference. I don't think that's tolerable. Depending on the nature of the lie and how I found out about it and whether we can move on from there or not, I may sever the relationship at that point. I don't recall I've ever had that situation, but that is certainly an option, and it may be the only option. Or it may be, you catch them in a falsehood rather than a lie, and say, look, we're going to have to be more careful from now on because I've got to have it straight. And we're in kind of a new world there because of the disclosure rules in the state, which means if there are bad facts out there, I may very well have to disclose them to the other side, which didn't used to be the case. And I can't necessarily say to the client anymore, you can tell me anything and it won't go outside this room. It may, and I may have an obligation for it to go outside this room. I think that, unfortunately, may tend to discourage the client from being as forthcoming as they might otherwise be, but those are just the ground rules these days. Nonetheless, I say to folks when I have to, I've got to know everything and I've got to know it truthfully and up front. And if you can't do that, again, you may want to go down the street.
In terms of the clients the new clients, is there a sense that you just want as many clients as you can get? I mean, sort of because of economics, or do you want to have clients or choose clients that you like their cases or believe in what they're doing or that they're long-established relationships? What is sort of the profile of what a client is in terms of what you do? And
well, in litigation in particular, you may have clients who are with you for long periods of time. I do employment work, and I represent clients who, because they have a lot of employees, have a lot of employment litigation, or they're getting dragged down to the Civil Rights Division or the EOC or whatever it may be on a fairly regular basis, and I can count on those clients year in and year out. Okay, this case is over, but here's another case. But the nature of litigation is such that you may have an enormous lawsuit that will take 2 or 3 years of your time. That case is over and you never see the client again. no matter how satisfied they were, because fortunately for them, they're not involved in that kind of litigation ever again. Antitrust cases, fraud cases, the kinds of things that don't tend to recur. It's a little hard in my practice to develop a profile of the ideal client, because while having clients who are with me on a regular and ongoing basis, the Arizona Daily Star and media work, for example, is terrific, and I love them. I've also had some excellent relationships with clients that I've never heard of. They show up, they got a litigation problem, we deal with it, and I never see them again. But they're still friends, we still exchange Christmas cards, we still talk to each other from time to time, and you know, maybe someday another lawsuit will come down the pike in Tucson and they'll be involved. So as I say, it's hard to do the profile. Quantity of clients really doesn't make much sense, again, in what I do, because you know, one lawsuit could take up 75% of my time at one time in my practice, and another time in my practice I'm working a couple of dozen different cases at once. That's just the nature of the beast. So I tend to worry more about, you know, how much work have I got on my plate, as opposed to how many clients do I have at any particular time.
Do you have to go out and find clients, or because Brown and Bain is so big, they just show up?
Both. We do a lot of client development work here, particularly in the employment field. We put on seminars, we put out newsletters, we you know, let people know that we're here and the kind of work we do. As by the same token, as you say, because of the reputation of the firm, work does come to us. A lot of our work comes from out of state. Again, clients who may find themselves through unusual circumstances involved in litigation in Tucson for the first and only time. They're headquartered in California or New York or someplace else, but they know somebody who knows somebody in our Phoenix office who refers them down to us. So business comes a lot of ways.
And then, okay, here's a stereotype that when you go to the corporations, we actually just heard this last hour. You go to the corporations, they're gonna be busting unions and working for people who don't have any heart, and that it's a bad place, and that you don't get any choices about, you know, you're just working for people like big corporations. And how's your response to that? I mean, because that's a that's a common thing.
Well, I have never worked, I think I can say this categorically, I have never worked for a corporation that I found morally repugnant. And I know that sounds arrogant, but I don't know how else to say it. I mean, my firm affords me that choice, not that it comes up all that regularly, but I'll give you an example. I know that I just remember back in the 70s, we had a client who was involved in nuclear energy. And frankly, I didn't then, don't now, have very strong feelings about nuclear energy one way or the other, so I worked for that client and I felt, you know, comfortable with it. But there were associates in the firm who felt this was, you know, morally repugnant to them, and they weren't going to work for anybody involved in nuclear energy. And the firm said, fine, we'll get somebody else to work on the case. So, again, I can't speak for most firms, really any other firm but mine, but I know that has arisen, and that's the way it was resolved. There are some clients that we have that I don't know, I may feel better about some than others, but that's part of the beast. I mean, again, it's part of what you accept. As long as you're not having to do something which is repugnant to you morally, but it's something that you can, you know, feel comfortable with, you're not always going to be working for Mother Teresa. Sometimes you're going to be working for people who maybe you're not as comfortable with as others, and sometimes you're going to be taking positions that you'd rather be on the other side of the case. If you always want to be working for Mother Teresa, and if you always want to be working on you know, the only side of the case that you believe in, then, you know, go hang out your shingle and God bless you. But when you do get involved with a larger firm, with a larger client base, those things will happen.
And why do you think that big firms or powerful firms, why do people attach that to them? Do you think it's just...
I think it's stereotypical. Again, I know a number of small firms, very small firms, who have very large corporate clients, who are their only clients. Maybe their only client singular. And they work day and night for that client and that client only. So it's again stereotypical, I think, to say big firms are like this, small firms are like that. I would just say to any law student who's contemplating a career one place or the other, find out everything you can. Talk to the younger associates. Talk to the people who are a year, 2 years, 3 years, 4 years older than you are, and ask them what's life like in this place. Have you ever had this kind of decision where you had to make? Did you take a stand? What happened to you? Ask questions, and I think most people give you pretty straight answers.
All right. How are we doing on time? Or do you have to be somewhere? Can we run over a little bit?
Sure.
Okay. Is that okay with you?
Yeah.
Okay. All right. Litigation. We've had some people talk about litigation. Who? What does Ted Schmidt do? He loved it. He had this like fire and power.
Yeah.
We talked to someone else who did it well, hated it, got out of it. Sort of, what is there a personality that goes along with litigation, or do you think that, I mean, why choose litigation?
Well, that's two questions. Is there a personality? The answer is no. One problem, you talk about difficult clients. One problem I do have with clients from time to time is, they say I'm in litigation, I want to hire a mean, vicious bulldog, to go and rip somebody's throat out. There are such litigators out there. I'm not one of them. I do it differently, and it's not necessarily because I choose to do it differently, that's just my personality. I'm not someone who rips out throats. I think what I do and how I do it is at least as effective as the bulldogs, but it's a different approach, and some clients like that and some don't. But I think they're equally effective. So no, I don't think there's any particular type of personality, as long as you feel comfortable standing up in court, in front of a bunch of people and arguing your case. Then however you do that really is up to you. Let me tell you what I like about what I do. I'm involved in civil litigation, not criminal, and I do primarily business litigation. So I don't do personal injury and I don't do other things. The reason I like doing what I'm doing is I get a tremendous variety of things to do. I have a large variety of clients that I work for who are in the media business, who are in the construction business, who are in all kinds of different businesses, and I enjoy going out, meeting them, finding out what they do, figuring out how they do it, and then how all that works into a case. One of my favorite days as a lawyer was when I was practicing over in New Mexico, and I spent the morning at one new client, which was Space Communications Company, which, as the name implies, was involved in communicating with satellites and the space shuttle and all that. They had these enormous arrays of antenna, which were pointed toward the skies, and they had this mission control area that looked just like Houston, and I was like a little kid. I just loved it. And I spent the afternoon at another new client, which was a hydroponic catfish farm. And I love that too. I just enjoy getting into that and learning about different things. And substantively, I have the chance to get into. Right now, my largest cases are a will contest and a couple of construction cases I'm doing. 2 years ago, I'd never done a will contest or a construction case. I've done antitrust cases, I've done consumer fraud cases, I've done employment cases, I've done First Amendment cases. I've just had a tremendous variety of things I've been able to do. And that's what I really like about it. I can get a case done, get it over with, hopefully feel good about what was accomplished, and then move on to something brand new. And I really enjoy that.
And what's the bad part? Is there a bad part?
Yes, of course there's a bad part, and one of them is having a bulldog on the other side. There are, unfortunately, lawyers who do not practice in what I would consider to be a civil or professional matter. They can be extremely difficult to work with for no good reason as far as advancing their client's position is concerned, but just because they think that's how they can be effective. There are difficult clients to work with. There are clients with unrealistic expectations, no matter how you try to counsel them. There are judges, of course, who can be difficult to work with, primarily because they don't see things your way, and all of that. I mean, there are tremendous frustrations. It's a very time-consuming profession if you're doing it right, but I think the rewards are very great.
And what's the difference between litigating? Actually, I'm going to make noise for just a second. We've been quiet for a long time. What's the difference between? Hold on, I guess I should wait. What's the difference between? Oops, hold on, I'm making one. Just a second. It's a problem with videotape. There's
Yes.
no. Okay.
Fortunately, there is editing.
Yes, exactly. What's the difference between litigating here and in Phoenix? Is there a difference? Is it a different atmosphere?
You know, I think you would get a very different answer, probably already have, from someone who's practiced in Tucson for many, many years. I hear from folks who've been around here longer than me, I've been here since 1989, that the practice in Tucson has really changed. It used to be much more of a small town, much more of a collegial atmosphere. Lawyers would get together over drinks and settle cases, that sort of thing. And now they say that's all changed. The Phoenix firms have come down here and ruined everything for them. I don't have a frame of reference, so I can't answer that. Notwithstanding all of that, I perceive a difference still between Phoenix and Tucson. I do think there's more of a collegiality down here, because even though there are a lot more lawyers here than there used to be, there still aren't so many that you can't think about meeting this same lawyer on the other side of a different case down the road, and so let's think about how we treat each other in this one, because while I may have advantages today, she may have the advantages tomorrow. Whereas in Phoenix, you come across one lawyer and chances are you'll never see him again, so people treat that differently.
How many lawyers do you think are doing civil litigation here in Tucson, just an average? Do you have any, like a 200, a 50, no sense?
Well, again, it depends on how you define it. I'm thinking in terms of the larger firms in town, which are the ones that I tend to run into most of the time. There are probably a couple hundred lawyers in those types of firms, not all doing litigation, of course. But then, you also have your small firms and your sole practitioners, primarily doing, for example, the plaintiff's employment work, who are involved as well. So it would be hard for me to estimate.
You finished too fast. Is my crunching too loud?
No.
Okay.
Just
These
right.
are important questions.
Just
What's your favorite part of litigating? Do you like the preparing, or the courtroom, or the trying to work out a settlement, or is it all fun?
Well, as I think I indicated earlier, one of my favorite parts is getting involved in a case for the first time and learning about it and thinking about it, strategizing about it, trying to figure out where I want to be at the end and how I'm going to get there. I enjoy that a lot, and then kind of seeing it all unfold. I suppose the opposite extreme to that is trying the case, which I don't do that much of because most of my cases tend to get resolved one way or the other before trial. When we do the trial, I find that I tend to enjoy the trial much more after it's over than while it's going on, because there are so many things to worry about and so many people to get prepared and get ready and get all the documents together and worry about the time limits and all of this. You really don't have much time to enjoy yourself, is my experience. But when it's all over, particularly if you get a good result, or at least if you feel like you gave it your best shot, I don't think there's anything more satisfying than doing that.
A couple of people, actually not in the interviews, but ones that I had read from a while back, and talking to my dad, who did trial work early in his law career, he said that when they were law students, they went down to the courthouse and they would see the great lawyers litigating. Do you think that kind of thing is something that, if a student's interested in being in litigation, should they be spending time watching you and your colleagues do it, or is there a place for that? What should they be doing to prepare?
Well, actually, I mentioned earlier the importance of having confidence in a courtroom when you get up to do anything, and I would say almost the opposite. That I say to young lawyers, if you want to increase your confidence in your ability to do something in a courtroom, go to the courtroom, sit in the back of the courtroom, and watch a bunch of lawyers do their work on a day-by-day basis. And your reaction, by and large, is going to be, I can do that. Unfortunately, I think there are, for every really talented and effective lawyer, there are several lawyers who are barely adequate. And that is one reason I think it would drive me nuts to be a trial judge. To have to sit there day after day after day and watch some of these practitioners do their work, I think I would find extremely frustrating. So I say to lawyers, young lawyers, go down and do that, and you're going to be surprised how much confidence you're going to get. But the opposite is obviously true too. If I mentioned Tom Chandler before, I would give anything if I could have seen him try a case. I never had that opportunity. He is just legend. But lawyers like that, I think anybody can learn from if they're not too intimidated by the experience. First trial I saw as a lawyer was conducted by my mentor Jack Brown, and to see him in a courtroom and to see him operate, on the one hand, was a tremendous learning experience, but it was also a bit intimidating. Well, I could never do that. So you have to kind of watch it. But, more noise. I guess I'm done with that.
Yeah, it's not our.
It's not ours.
Actually, it might be. I don't know. Okay, just one or two more questions, and
Okay.
then we'll be done. I don't want to take advantage of your time. All right. So, what should you with the judge? We're interviewing lots of judges, and I want to sort of. How do you approach the relationship with a judge? Is there any sort of strategies, and is it different depending on the personalities of judges in terms of the way you, or are you just who you are with whatever judge? I mean, you know what I mean? Like, how do you negotiate that relationship?
For some reason, I'm reminded of Dwight Eisenhower's line when he left the presidency, and they asked him what differences there were now that he'd left office, and he said, "I'm losing a lot more golf games." I suspect judges tend to do very well in their golfing outings. In terms of how you approach it, the first and absolute most important thing about your relationship with the judge is credibility, particularly in a town this size, because we only have, 6, 8 judges in Superior Court on the civil bench. Maybe it's more than that now, but a handful relatively. So these are I see the same judges all the time, and they see me all the time. And if they catch me playing fast and loose with the facts, if they catch me trying to sneak something past them, not only is that going to hurt me in that case, they're going to remember. And that's not going to do my future clients any good when I appear before this judge next time. So I think absolutely, first and foremost, credibility. Be straight. Give them the facts. Concede what you have to. Let them know that they can rely on you to give them an accurate picture of the facts and the law. Now, they understand you're going to advocate and you're going to make your arguments, and they expect that too. But they want to know, when I ask you a question and I need a factual answer, you're going to give it to me. And that's just key. Everything above that, I think, is pretty much surplusage. Be courteous. Treat the judge and the courtroom with respect. Do all the things that you need to do. Laugh at their jokes if you have to. But by and large, I try to stay on a friendly basis with them. I try not to argue. I certainly try not to be obnoxious. But if the judge has made a mistake and I think I can correct it and my client needs me to, I'll work on that one way or the other. But the important thing is to maintain credibility.
All right, last question. Well, two more
Nah,
questions.
that's
Two more. Because we'll ask the first that. We'll talk about this off tape, but you're heading the ADA's diabetes walk this year for Tucson, and I wanted to know, and this will be after that's happened, so no plugging.
Right.
So,
Well, we got another one next year, so
that's true.
every October.
And I wanted to know what sort of role does these sort of extracurricular activities play in your life as a lawyer, and is this a new thing or something that you do a lot of sort of other things besides?
Well, I think it's important for anybody, I don't care what their career is, to have other activities going on. And it hardly matters what they are. But in our profession in particular, and in my firm in particular, we are encouraged to get involved in community-related activities, however they're defined. Some of those you do because they'll help you meet people and help you develop a practice and all of that, and some things you do just because they make you feel good. In the case of the diabetes walk, I do it for purely selfish reasons. I'm diabetic myself, and when I got diagnosed several years ago, I contacted the American Diabetes Association, got to know people here, and they sucked me into the organization. And so one of the things I'm doing is walk the 2 years before me. Pam Treadwell-Rubin is working with us on team recruitment this year, as is Chris Starring. So we have a number of lawyers who are working on this. And I'm reminded as I'm going through this of an organization I got involved with shortly after I came to Tucson called Lawyers Against Hunger, which was started by Paul Marcus when he was dean of the law school here, as well as Barry Corey. The two of them got the idea of an organization of lawyers, the purpose of which was to support the community food bank. And really the whole idea is, let's go out and raise a bunch of money and let's publicize the fact that we've done that. Number one, to raise money for the food bank, but also to let people know that lawyers aren't necessarily all slime, and they really can do good things for the community. So it wasn't all altruistic, but it was a wonderful organization, still is, still exists, and still does good work. And I think these are important for anybody really to round out their lives.
Okay, last question. What is, we've asked this almost everybody, this is a kind of dorky question.
What's your favorite curse word?
Pretty close. What's your happiest moment? Do you have any particular happy moments in law that when you think about, like, moments that you were just, and it's been really different for different people, but
I mentioned the day that I spent at Spacecom in the catfish farm as a day I particularly enjoyed. Anytime a jury has come back and said, I win and the other side loses, that's always a happy time. I think of another moment. Again, when I was in New Mexico, I was representing a fellow who was a lawyer in Florida and had some disciplinary issues down there as a lawyer, which really were relatively minor. But he came to New Mexico to practice there, applied for admission and was recommended against admission by the admissions committee primarily. I'm sorry, the admissions committee recommended him. That's right. The admissions committee recommended him, but it went all the way to the state Supreme Court because a couple of the justices took a very hardline approach to this and said, if you have any disciplinary issues anywhere, you can't come in here. So we had about an hour-long argument, at the end of which the court voted 3-2 to let the guy in. And at the end of the hearing, as I was walking out of the courtroom, he just threw his arms around me and said, thank you. For whatever reason, that moment it struck me particularly because I think it was the right thing. I mean, I knew he'd had some problems, but I was convinced that those were minor and past him, and there was really no good reason to keep him out of practice. He's been practicing ever since. I think he's been doing good work for his clients there. I'm happy about that, but it was an example of the kind of difference you can make. I mean, this is nothing earth-shattering. You know, I didn't stop, some enormous development from plowing out Yellowstone or anything, but on a one-on-one basis, it just kind of was a reminder of why we do what we do and how we can make a difference to people.
That's a nice note to end on. Well, thank you, and thank you for going over.
Certainly.
And,